posting just the PowerPoint, and then YouTube and Twitter should be on. Right now, you're probably looking at the presentation page. But welcome to my Facebook friends and family, to my webinar guests, and to those watching on YouTube and Twitter. This is our monthly webinar series. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. We are a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Nutley, Montclair, New Jersey. Today's webinar, I'm not sure if I said the title when I said about monthly webinar, Preserving Fathers' Rights in Custody Cases. Those on Facebook will only get to see the sign. I'm doing simultaneous posting, so let me give you a little bit of what to expect through the webinar today. All right, so it's set to be a 60-minute webinar. I usually do my best to stay inside that time frame. This time is actually the first time I'm not timing the presentation, but I'll do my best to keep it within the time frame I think it's supposed to be, because I want to respect your times for being here. It's a one-way communication on all these forums. The webinar has a control panel on the right side where you can post questions. My Facebook friends and family are able to post online if they don't mind other people seeing their comments. And then YouTube, you can post on YouTube and Twitter, but I won't see that because I can't see the feed while I'm doing that live posting. So you may be better off just to email a question afterwards. To those on the webinar who are only seeing the PowerPoint with the control panel, you can post questions on the right bottom side of that. Now, I don't look at the questions during the presentation because it just throws off my timing, but I will get to them afterwards and answer every one, so you need not worry. I usually recommend you put the questions there throughout the webinar so that you don't forget about them, even though I'm not going to address them immediately, make sure that they get addressed when they're there at the end. I will take as much time as necessary after it, even if I'm here past the 60 minutes, I will stay to answer all the questions that are posted. Again, those on the webinar, on the bottom right is the PowerPoint presentation if you want to download that for yourselves. In most cases, it's usually helpful. I don't know so much in this one. It will list the statutory factors in some case law, but not a great deal. But it's still good if you need it as a reference to print it out. This will also, as I said, I'm broadcasting live on several different media, but I will post this recorded version on my website, micklinlawgroup.com, usually a couple weeks after I finish recording this, and when I'm done the live recording, it gets onto YouTube and Twitter also, as well as Facebook. So anybody who signs on late can catch the rest of it. You can also watch this later if you need to, or send it to somebody who might benefit from it. So with that, let's move along into some of the information. Give those who don't know me a little bit of information about me. To those on the PowerPoint only, and that haven't worked with me, this is me. Just quick, I'm going to just throw up my criteria and quickly. Founded the Micklin Law Group, national media legal analyst. I didn't write that. I don't like to say that, but I have been fortunate to make many national media appearances commenting on different various legal matters. We are focused on men's and fathers' rights, and I'm admitted in New Jersey Federal District Court also. By way of some background, my education in law practice, I started my clerkship out of law school in the early 90s. I then did some complex commercial litigation with Kessler & Associates for a couple of years, and then realized I didn't care much for commercial litigation. I like to really deal with people, so opened my own practice in 2001. At that time, I was a general practitioner, which means I did a little bit of everything. And I quickly came to realize you can't do a lot of things well. You can only do a lot of things fair or a few things well. So I decided to concentrate my practice at that time into family law and divorce. And over the years, and not too many years ago, is where I started concentrating solely on the men's and fathers' rights. So let's talk a little bit about the agenda for today. I'm going to switch back and forth to those watching on YouTube so you get some different views. I don't know if the camera I have does it right or not. First, we're going to talk about the custody statute 9:2-4. It's an important statute. If you have young children, I'd write down the number if you're not going to take the PowerPoint. It has a significant amount of factors that we will discuss today, but you want to have that number so that you can reference it and look to the specific factors if you have your own case. So we're going to go through those statutory factors also. Legal versus physical, there are many different custody distinctions. I always tell clients really to stay away from using them, because if you use the wrong one, you asked for the wrong thing, but we will talk about them. So the first two will be legal and physical. After that is sole and shared. These are not mutually exclusive. You can have combinations of any of them. We will talk about how that is. Different types of shared parenting arrangements, more based on like a time sharing, not a legal custody or decision making. Then important points that you want to keep in mind, specific topics that may relate to unmarried fathers as opposed to fathers, because the court system is a little more complicated if you're in a divorce, let's say, or if you're married while custody. And relocation, which is obviously one of the biggest, most complex issues and most difficult that most will face in custody. And then lastly, just some hot tips, just things to keep in mind and developments in the law that you should be aware of. With that, let's talk about the custody statute that I mentioned. So first, the statute is and always has been general neutral, meaning there's no preference for custody of one person or another. There had been, it still technically exists, a doctrine called the tender years doctrine, which basically held that a child of tender years was best suited with his or her mother. Now, technically, it's still kind of on the books, even though it's not a statute, it's a case law distinction. It's still around. It's not utilized too often. I think most recognize that either it's not applicable or that most people find it not applicable. So even those that think it's still accurate know that there's not much room for using it. Best interest standards that we'll talk about. That is basically the catch-all standard for any significant change in a custody issue, whether it's the type of custody, the parenting schedule, relocation, all the issues I said we're going to talk about. Most will turn on a showing or lack of showing in a child's best interest. Presumption in favor of frequent and continuing contact with both parents. This is basically what the statute requires or promotes. There is a movement towards a presumption of equal physical custody. We're not there yet, but we are finally recognizing the statute that has always said that there's a presumption in favor of as much contact as possible is basically what that is. And that means equal rights for both parents. So no one person has a paramount right to custody. All right, so let's take a closer look at the actual statute. There's a lot to it, so bear with me. We're going to be here for a little bit. All right, mothers are still commonly awarded custody because they're more likely to be primary caregivers, and courts favor existing arrangements to avoid upheaval. What that means is, and I'm going to say it, we currently, at least in my practice, in my area, I'm in North Jersey, I still find a greater portion of my clients where they have the father who is a primary breadwinner and the mother who is either the secondary breadwinner and the, let's say, primary parent or stay-at-home parent parenting their child. Now, that's not to say that every situation is that way, and it's not to say that certain women aren't the breadwinners and fathers are stay-at-homes, and I get all that. I'm not saying it doesn't exist. What I'm saying is that the majority of cases that I deal with still have more of a traditional setup when they come to my office. Good, bad, or indifferent. That's the way it is. So when I say that the courts are still favoring giving a mother custody or greater custody rights or times, it's not because of a gender issue. It's because the belief is it's best to keep as much consistency and stability the child previously had for after the divorce. So if that was the situation that existed, that's what's going to continue. And it has nothing really to do with gender. It has more to do with the decisions that the parents made during the practice. Work schedules play a big role and requirement to send custody to parenting. So first, these two sort of go together because they're the initial part of what's going to happen in your custody case. First is the schedules tend to play a big role because courts are not going to decide, like I said, based on gender and who they think is, what gender is the more appropriate parent, but they're going to look to what's actually happening. So if you have one parent who is working 9 to 5 in New York City and gets home at 7, and you have another who's a teacher, leaves at 8:30 and comes home at 4, that's going to play a big part in who's going to be the main custodial parent when there's a dispute. But you're going to initially start with the fact that any custody case whether you have a standard traditional like I've been describing or some new issue that arose, you will always be first sent to the custody and parenting mediation. Now, the statute says you're supposed to go, or the court's supposed to send you when there's a genuine and material dispute in custody. Now, that's not always the case when people file. Sometimes people will file. There really is no change of circumstance. There is no reason to upset the status quo. The court will still likely always send you to custody mediation. It's very rare that a judge would say, I don't find any issue here, and just dismiss the case. Not when it's about custody issues. But it's an important point to know because you may be on the side seeking to dismiss it. You do want to raise the issue, even though it's not likely to really make much of a difference. Moving on to more custody issues. Let's look at some of the things that judges will use to make custody decisions. It's not just you walk into court, you tell the judge what you want, and you get a decision. There's many steps and many players that will be involved. So let's take a look at some of them. First is the appointment of a guardian ad litem or an attorney for the children. Now, they're separate roles. Now, they both serve a similar role, and that is to advocate for the voice of the children. But there's a varying opinion on how they're actually supposed to do that. And I'm not going to go through the specific guardian ad litems and the attorneys and the differences. A little too broad for this. But basically speaking, the court can appoint an attorney to represent the children. That attorney's role is to either find out what the children want and actually advocate for that. That's one view, regardless of whether it makes sense or it's the right decision. The other view is that the guardian ad litem or the attorney is supposed to advocate what would be in the child's best interest. There's no set rule for that. More people lean towards advocating what's in their best interest and not what they want. And let me say, the reason why some say it's supposed to be what they want is because if you're the attorney for the children, your job is to be their advocate. And if they say they don't want to go to the dentist, that's what you're supposed to advocate. But it becomes ludicrous in a lot of circumstances because children just can't make that kind of decision. They're incapable of making that kind of sophisticated decision about parenting. So there's no set rule of how it's supposed to be managed, but more lean towards advocating what's best for the children. Interviews, everybody comes and says, I want the child interviewed, I want the judge to talk to the children. First of all, I never recommend that because you never know what a child's going to say. Children will, first of all, if they're old enough to know what's going on, they're going to want to appease both parents and they're going to play both sides. You can't trust that what they're telling you is what they're going to tell a judge. It also is going to determine or depend on who took them to court that day, who had the weekend before, who has more contact. So you never want it from a parent's standpoint. Now, I was going to say unless you're dead certain, but you never want it because you can never be dead certain. Judges also aren't big fans of it. I find less and less judges are doing it, partly because they don't want to put children in between their parents. It's never helpful. Partly because many of them recognize they don't really have any sufficient background to make a determination. It's not like they're children's psychologists or educated in these fields. They have a great deal of exposure to them, but it doesn't mean they have any more knowledge or insight than the rest of us do. So little can be gained from an interview, so many of them don't do it for that reason. Best interest evaluation risk assessments are very common. Now, the best interest analysis is very common in a custody matter. Risk assessments, not so much so. A best interest is, in a nutshell, where the court will send somebody or the parties retain somebody to go out and make sort of a home analysis investigation. Is there food in the refrigerator? Is it clean and safe? Does the child have a bed? How many plugs are in the outlet? And then they report to the court. It's not a report that makes any kind of recommendation. It's more just a historical account and getting the sides or opinions from each of the parties involved. Risk assessments are a little different. They're more often when there's either domestic violence, history or allegations, or some other issue like drug abuse or drug issue, where they feel there might be some actual harm to the children, so they're going to send and do a specific risk assessment, usually done by a certain organization that sometimes the courts will have that they will send you to. Others can retain somebody to do it privately or both in a lot of cases. Appointment of forensic custody experts, that's a fancy term, but custody experts aren't that uncommon. And I hate when I do that because I hate speaking to double negatives. They're common in custody cases. Now you can either have the court appoint somebody, or each of you can get your own person, or you can each agree to your own person, or a combination of all of that. Generally speaking, my recommendation is to let the court appoint somebody or choose a joint one First, because it splits the cost and you might get a good report. And if you don't have a good report, you still reserve the right to get your own after it. So you get like a second bite of the apple, which you don't have if you get your own report right out of the gate. Appointment of therapist, reunification therapy. This is going to be more of a fact-specific case issue. Reunification therapy is common where there's been parental alienation, which I know is a very big, popular word. People use it all the time. But true alienation is not as common as you think. It takes a very long time. So it's not as common. Therapists are quite common. They are used in custody cases not to help the court determine the custody issue, but to sort of minimize the conflict and the difficulty, especially if there's going to be a transition in custody. And then shifting of fees and costs where appropriate. This is usually more of a tool to either discourage litigation or bad conduct. The court can make one person pay the other person's legal fees. They can make the payment of expert fees as a sanction. And they can also do it when there's an economic imbalance. So if one party earns substantially more, the courts find it just to have that person pay more of the expert fees even for the other side, just because otherwise they wouldn't be able to wage the same kind of battle and it would be unfair to the child. More on the custody factors. Like I said, there's going to be many of them. First is a parent's ability to agree, communicate, and cooperate in matters relating to the child. Biggest one, most important, the most difficult in situations. Generally, if you're in court on a contested custody matter, it's because you can't communicate and agree in matters relating to your child. The important thing about this that I've come to realize in the last few years, I try to explain to my clients, is you have to be careful how you advocate. People want to go in and say, well, the mother doesn't, and I'm saying mother because I do men's and fathers' rights, so no offense to ladies. Mother doesn't let me parent, she's impossible, we can't make decisions, so I should have primary custody. I should have equal time. Sometimes they use it just to get equal time. But that can cut both ways because the court needs to know that you can communicate and cooperate. The focus for the judge, and this is what's always important to remember, the focus for the judge is always the child. The judge could care less about you or your spouse or your wife or the mother, your problems, your past. They only care about the child. So even if, in the example I just gave you, the mother is unreasonable, impossible, and frustrates cooperation, if the child would be better with that parent because it's the status quo, because she's closer to school, because whatever the reason may be, testifying that communication is poor may turn against you in that person's favor, even though they're the ones making it difficult. So I stress this point because of all the factors, I think it's going to be the most important, and I think it's the most incorrectly utilized. Willingness to accept custody and history of unwillingness. I've always found this a little awkward because you wouldn't be in a custody case unless you were desiring custody. Sometimes rare, you'll have a custody case where the custodial parent has shown times where they were unwilling to keep custody, and that's more often when you have teenage children and the problems that they bring. You'll find mom dropping off at dad's house because they just can't tolerate it or they don't have the ability to discipline. So if you have those issues, it's important to know, but most of the time it's not going to be a huge factor in most cases. Interaction and relationship of the child with parent and siblings. Now, siblings can mean it's their own siblings. It can mean stepchildren and other families. We have a lot of blended families these days. The interaction, again, it's going to be important. You want to make sure that there's a good bond between the child and the parent and their siblings, and more importantly, that there isn't any problem in the home regarding these children or regarding the siblings and other relationships. Otherwise, it's not that big of a factor absent that issue. Next. Got a big fist showing for this one because we're going to talk about the main issues now. History of domestic violence, if any. Now, this is a very significant issue, and it comes into a couple different aspects of the custody statute factors. History of domestic violence doesn't need to be temporary restraining orders, final restraining orders, civil restraining orders to what people. Domestic violence can be just the acts that occur that are violent, or not even violent may not be the right characteristic for it, that commit domestic violence or an act of domestic violence. So there might be verbal abuse, there might be physical abuse, it may be undocumented, it may be against, in front of the child or towards the child. Custody factors or custody cases with DCP&P can also be an issue. So it's important to go through and enunciate what the history was, even if it's never been reported, even if there's never been any kind of orders or court adjudication. You still want to mention, I think it's very important for judges to understand the housing situation and relationships that will be entered, especially if the domestic violence is with the other parent and somebody else, meaning you have, you live physically separate from the mother and she's in an abusive relationship. That's going to impact the children or your child greatly. So you want to bring that in as possibly and as strongly as you can. Safety of the child from abuse by other parent ties a little bit into the first factor, but now goes directly to the child. Children are considered victims of domestic violence by the simple fact that's occurring in the house. So even one parent abusing another impacts the child and is abuse on the child. The more involved the child is, the more of an impact it has, and the more the child is considered a victim, but always considered a victim, whether it's to the child or not, even if the child's not present. So the greater the domestic violence, the greater the risk to the child, the more the court wants to know about it. Preferences of the child when of sufficient age. That's a tough question. In my opinion, courts don't even consider listening to a child before that child is 13. And even then, first, if they are going to listen, doesn't mean they're really going to give a lot of weight to it. And I've seen judges who don't want to take any child's. I've had a case where there was an 18-year-old and there was a custody issue because of college, and the judge didn't want to talk to the child. Partly because it's still a difficult, sophisticated decision to make for an 18-year-old, and they don't want to put the child in between their parents. There's little to gain from that for the child. And again, everybody's concerned for the child, not for the parent. So it's something that's important. It may also be one of the few times where the judge does have the in-camera interview I mentioned earlier. That doesn't happen very often. But that could be where it's applicable or necessary. Needs of the child. This is going to also be a very fact-specific discussion, and you want to look to every need the child has, not just significant ones like medical, education, or religion, but their personal needs, their idiosyncratic needs, their habits and their friends. Children need a lot of things, obviously, so it's not just that they need to have good schools near them and be close to a hospital, but they also need to have a playground. They might need to have a backyard. They might have to have the friends that they've known. I have one client who has a very shy child, and groups really impact her greatly. So she stays with a very close group of friends, very small group of friends. Taking her out of that group would be very difficult. She has a unique need to stay in an area where her friends are. So you really have to look deeper than what people commonly think needs are, which would be religion, medical, educational, residential. Those are like the top four, but those really aren't they are the most important, but they're not the only ones. I think you really need to dig a lot deeper when we're talking about children's needs. Quick hello, see my wife signed on. Always gotta say hi to my wife. Sorry for those that are going through a divorce or a tough time and may have been insensitive, but sorry. So getting back, just always like to check in with my Facebook friends and family, say hello, because I appreciate the time and support everybody gives me there. Back to the stability of the home environment. That can include many different things, not just how long they've lived there, but the likelihood that they're going to remain, how much accommodations are provided. Is there extra rooms? Is there privacy? Are there 7 people living in one family, 1 bedroom? It's important. It's also important to note that it's not a deciding factor. Judges don't require a child to have a bedroom. Because you have a 2-bedroom doesn't mean you're going to get custody over the mother who has a 1-bedroom. It's an issue, it's a consideration, but it's not a deciding one. Continuity of education, important, very important. Also, depending on the child's age, it's not so important if the child's in preschool or kindergarten, but if they're in 8th grade, continuity is going to be more significant. So the older the child gets, the more important this factor is going to be. So you want to look to how each one of you will either provide or can't provide continuity in not only the current education, but you got to look down the line too. You got usually many years ahead of you. Fitness of the parents. This is an issue that, even though it sounds like it would be significant, usually doesn't come up so much because the courts are going to presume, and the law presumes, the Constitution presumes, that you're fit to be a parent. Overcoming that presumption is very difficult. Now, I'm not saying it's impossible. It's actually common in many circumstances because you have things like DCP&P and abuse and neglect cases where there are serious fitness issues. But in your average case, your day-to-day case, your garden variety case, fitness isn't going to be an issue. And just like communication, where I said before, you don't necessarily want to raise an issue to say that the other parent is a bad parent because they can't communicate. You don't necessarily want to raise and trample on the other parent saying that they're not fit unless you have a real credible explanation for it, because it undermines your credibility. It looks like you're just there trying to punish the mother, and then they wonder if that's really the reason you're seeking custody. So it's an issue that you more often than not skip over. Moving along, more statute factors, geographical proximity of homes. This is important when it comes to, well, for many things, but I think it's most important when it comes to time sharing. So when you look at continuity of education and you're looking at a time sharing dispute where maybe one parent wants 50% and the other parent wants primary custody, you have to look at how close they are, not only to each other, but also to the schools and other resources that you're going to need. Is the child going to have to get up at 5 o'clock to be driven an hour home from Middlesex County to make it to school in time? And in those kinds of cases, it will impact how much sharing you'll get, and it can greatly impact the ability to get equal sharing if it's not convenient. Time spent, quality of time spent before and after separation. This goes a little bit to that status quo situation that I mentioned before, that they want to see, not only because it's best for the child to have continuity, but also it goes a little bit, it goes a lot to the motivations behind the filing. If you were, for instance, a parent and you were working, 9 to 8, and on the weekends, and now you're in divorce and you're asking to be primary custodial parent, when they look at the fact that you were not probably around a great deal, and I'm not saying that's a bad thing. A lot of people need to do that to provide for their families. It's just the way it is for a lot of people. But to come into court after a situation like that and say, well, now you should be the primary parent because the mother is unfit and can't communicate, it undermines the credibility. So you need to carefully evaluate the time you had before and how that's going to impact the decision in the future, at least so you're aware of it and you can address it. There may be a compelling reason why you are now the more appropriate parent for primary time. It might be that you're not working and that other spouse or parent is working. But you need to explain it. Employment responsibilities kind of goes to what I was just saying. Obviously, it goes to availability and time. It goes to finances. And it goes to the motivation of custody. If you're, and the best interest, obviously, like everything. If you're working so much, or even if you're working so much more than the other parent, that you're not going to be with the child as much as the other parent could be, it goes to at least a time-sharing issue. It can also go to something that we call the right of first refusal, where most people should agree that when they can't be with the child, the other party gets to be, or the other parent gets to be with that child. So you may have a time-sharing arrangement, but that work responsibility may force a greater sharing under the right of first refusal if you're not going to be around as much as the other parent might be. Age and number of children, obviously, just because they don't want to disturb the situation. Let's say there's many siblings in one house. There could be several children party to this action. We don't want to separate them. They could be of different ages, so maybe it does make sense that you can separate them. So age and number are very important. More important, the more children you have and the older they are. All right, so let's turn to some of the more complex issues that people ask about. Legal and physical custody. Important distinctions. Legal is who makes the decision, and physical is about overnights. Now, I'm going to go into some of what those issues are and some of the terms, but I do want to say first of all, this is mostly going to be joint. In 99% of the cases in New Jersey, you're going to share both. It's important to understand that when it comes to physical custody, where the child is sleeping, even if you have joint, that doesn't mean you have equal. And that's where I get a lot of people that get confused. Joint just means that you're sharing overnight. So one parent could have 364 days and one parent has one overnight, and that's still going to be joint physical custody. So don't go into this or into court thinking that joint is equal. It's sort of with legal custody, but not with physical. So legal, it's about major decisions: religion, medical, educational. I always also add in residence because relocation becomes a very big issue. This is for legal custody. These decisions will normally be jointly made. They have to be with input of the other parent. We'll get to an issue of parent of primary residence in a few minutes, but even when there is, these generally have to be joint. When there's not agreement on a significant issue, it usually needs to be decided by the court. As opposed to day-to-day decisions, homework, bedtime, what doctor they see, what daycare they go to, that's more often either the parent of primary residence, which we'll talk about, or the parent that has the child at that time. They have parenting, so they make the day-to-day decisions on their time because they're the parent. And another example, extracurricular activities. I forgot that one. All right. Moving on to the next big issue, sole versus shared custody, which I started to allude to when I talked to joint and legal. And remember what I said when I signed on, these are not mutually exclusive. You don't have legal custody or sole custody. You could have sole legal custody. You could have shared legal custody, same with physical. Sole means you make the final decisions. Now, most judges will say that you should still seek the input of the other parent, but it's not required. And you don't necessarily need to come to the court for decisions on significant issues where there's no agreement. I think the case law is a little unclear about relocation. Most judges I find still find that relocation needs to come before the court even with sole custody. Check with your jurisdiction and at the time you're doing this, because again, this is in 2019 and I'm not sure when you're going to be watching it. But sole, as I said before, it doesn't mean zero. It still means input. With physical contact or physical custody, you can still have overnights also and still have sole custody. You're not usually going to have sole physical custody when you have sole legal custody, although you could. And you're not likely to have sole physical and not have sole legal. And I know I might be going too deep into it with the overlapping, but sole still means the other parent can be involved and in limited circumstances may still be required to be involved. That's what you should take from this. Share doesn't mean 50-50, covered that already. Definition of overnights, this becomes more important for child support, but the child support guidelines are required to be 12 hours or more. So if you're picking a child up, for instance, at 8 o'clock at night and bringing them back at 8 o'clock in the morning, that technically is an overnight, but it may not be counted as an overnight because you're not really providing anything other than a bed for the child. You're not providing any meals or any entertainment, clothing. So the overnight is supposed to be, the reason why overnights are important for at least child support purposes is because you're providing for the child's needs during that time and you get an adjustment depending on the night. So it's important to know that it needs to be 12 hours or more, and it doesn't always mean that that does count it, so you got to be very specific. And if you're making an agreement about child support, so let's say you're deviating from the guidelines or you're making a custody arrangement, you can define how that is. For instance, I have a case where my client and his mother have the child from 9 in the morning till 5 in the afternoon or evening, then the mother picks up the child and goes home. Now, my client only has a handful of overnights, but he has a child 50% of the time the child's awake, even though it's not 12 hours. So we're taking the position that that should be considered an overnight and there should be equal parenting because we have more than equal time of the child's waking time. We're providing more of the needs and resources for this child. Parent of primary residence, parent of alternate residence designations, and alternatives. There's a trend towards not having a PPR or designating both as PPR. The only reason that I've seen PPR designation being truly relevant is for school registration. A lot of All I'm going to say, again, I might get a lot of backlash from this. A lot of women are still seeking the PPR designation. I personally think it's because they're accustomed to that being significant. Their friends, their family, their parents, they've had it or they're aware of it, and they maybe feel like they're losing custody if they don't come out and say they have it on the PPR. But PPR, I think, has lost a lot of its significance other than school registration, which you can use language to get around that. Because any important decision, as I said, has to be made with both parents involved. The other parent always has the option of going to school, the parent of alternate resident, the parent who is not the PPR, can always go to court to block a decision, and the fact that they weren't included would actually lend great weight to blocking that decision. And there are very few things now that are even considered day-to-day that aren't significant, especially when you have an equal custody. What extracurricular activities a child's in is very important if you have equal physical time, because it's going to impact that other parent's time. It's also going to impact child support. So there's a lot of issues. The Deffler case just threw this in. It's more of a child support issue, but it's significant in custody because 50% or equal physical custody is a common growing trend. This is the case that explains how child support gets adjusted if you're sharing equal physical time. I'm not going to go into it in great detail because it requires that I first explain how the child support covers expenses and then how the Deffler case allocates it. But the simple fact to know is that this case is what, first of all, you'll hear in court, but also what you should be aware of and possibly read. This is a case that will adjust your child support if you share equal physical time so that you're accounting for all the resources that you're providing for the child during your time. So let's look at different time sharing arrangements. This is where we're talking about physical custody. An equal physical custody more often is going to be a week on and a week off. In my experience, parents, depending on the needs of the child, this usually works pretty well for the child because there's a lot of continuity and not a lot of shuffling. It doesn't always work so well for the parents. Most parents don't want to go 7 days without seeing their child, understandably, but it's a more common arrangement. The next that I often see is a 2-2-3, meaning 2 with one parent, 2 with another, 3 with the original parent and alternating. One thing I forgot to put in here is also a 4-3 schedule, which I actually think is probably the best schedule for equal physical time. I think it gives the child a big enough block of time where they're not coming back and forth a lot, but it doesn't give a great absence of time away from the other parent. And because it's so close to equal, your weekends will eventually alternate, so you'll get your weekends. Your holidays will eventually alternate if you don't make a separate schedule for it. In my experience, it's probably the best equal physical custody arrangement that people can have. Quick check-in. I see a new client of mine sign on. Good to see you again. Okay, now that, like I said, the 4-3 is the one that I see working the best. Nesting is the one I see working the least. A lot of people think it's good for the child, and maybe in certain cases it is, but I haven't found it to work. Nesting is where you have one house where the child resides, usually the house where the child was residing before the custody issue arose, and then there becomes a second house where either one of the parents moved to, whether they had the house or they rented another place. So the child stays in the house all the time. It's the parents who alternate. So one parent could be there for 7 days and then switch, or the 4 and 3, dad's there for 4, mom's there for 3. The child always stays there. And it sounds like a great situation because it's stability for the child. You have everything the child needs in one place, so you're not packing bags and forgetting iPads. But it only works, if at all, when there's a great deal of cooperation between the parents. And not parents who are willing to cooperate, but parents who have a history of cooperation, significant amount, because it's challenging. Not only because it's a demanding schedule, but it's challenging because now you're maintaining 2 houses with a person that you may not be too fond of. And there's issues when you come back. Did they take out their trash in the main house with the child or in the secondary house where you're alternating? Did they clean up after themselves? How are you paying the bills? It can be a mess. In my experience, I've never seen it work, but I've also only seen a handful of people try it. So in fairness, it's possibly going to begin working better because people are aware of the problems, but in my experience right now, it's not something that I recommend for most situations. Again, tying the parenting time to the work schedule, very common. I would urge anybody in a custody case to put aside your differences and look at this because it's important to the child, but it's also going to be important to the judge. And again, if you go in arguing that you should have more time than mom, even though you're working more, it's going to take a lot of credibility out of your issues and count against you significantly. And it's also not good for the child. The child should be with a parent over a babysitter, if possible, more often. Summer and holidays, it's important. First of all, you want to consider this when you're working at custody arrangements and child support. You want to map out a good schedule. You also want to have conflict resolution built in. And what I mean by that is what's going to happen on the summer if both of you want to go at the same time. What happens if you both celebrate the same holiday the same way? And also, more importantly, what I tell a lot of my clients is, even though you might not have the issue now, as you get older, as the child gets older, as you have more people come into your lives, these will become greater issues than they may seem. Another issue to the people who will be paying child support, who are to those who are not going to have equal physical time, meaning they have less. One thing you can consider is also making child support temporarily terminate during extended overnight parenting time. So if, for instance, mom, as I'm talking to men's rights, if mom's going to have 2 weeks of vacation time, then you can agree in advance that you won't be paying child support during that time. The guidelines do not provide for that because the majority of expenses that child support covers continue to accrue, but you can still agree to that. So just make a note. Moving on to some of our closing points, I think. Miscellaneous important points to keep in mind. Always a lot of them. And a lot of these are going to tie back to what I said before, but sometimes you want to look a little more closely into them specifically because they are so significant. And we brush over them because I try to keep this within an hour. Best interest standard. Again, as I opened with, the most important thing to understand about custody cases, and ironically, the thing that you'll get the least understanding of, because there's nothing that says, well, this is what is in a child's best interest. You can't read a case or a decision or a statute and it'll tell you this is what's best for a child. Each one is going to be fact specific and it's going to be judge specific. So you need to realize that, but also, and probably the most important thing I've noticed in this is, and it goes to relocation, so I'm not sure if I get back over this, but I'll say it now just in case I don't. Best interest of the child, if you listen closely, it's the best interest of the child. And I say that as self-evident as it may seem because most people will come into court, especially in relocation issues, arguing what's better for them. I want to move to Florida because it's nicer weather, because my mother's there to give me support, because I can get a better job and I'll have more money, I'll be off. None of that inures directly to the child. Now, I get all of that benefits a child, but in the way it's being presented, in the way I just said it, which is the commonly way it's being presented, that's about the parent. Now, of course, it benefits the child, but you're arguing best, not better. So when you're arguing best interest, you have to argue things like the better schools for the child, the better extracurricular activities for the child, there's more parks for the child to attend, she'll have more friends, there's more student-teacher ratio is better, less crime. These are things that impact the child, and then you can argue why it's best, because then you can also compare number to number. Student-teacher ratios, numbers of schools, number of parks, number of extracurricular activities, number of children, crime. These all have statistics that can be measured, and you can then say it's best because whether here is here and this is better. Next is change of circumstances. The second most important thing, ironically, is probably the first thing that comes up, but the second most important because best interest is always most important. Change of circumstances may trigger a custody dispute, but it's got to be a substantial and material change of circumstance, which is what's important to realize. Just because you lose your job may not be that significant. Just because you have a decrease in income may not be that significant. A child, unfortunately, getting an illness may not be that significant. But at the same time, they all may be. This is another one that doesn't have any bright line where you can go to a statute and read, well, this is what a change of circumstance or a substantial change of circumstance is, and this is what's not. Each one's going to be fact specific. But you do want to carefully consider whether or not what you believe to be significant or substantial material change of circumstance, whether it is or not. Speak to an attorney. I was about to say speak to some friends, but I wouldn't do that because you usually get horror stories. So speak to an attorney. Don't go to the internet, even though I'm on the internet now. I generally tell people to stay away from that too. But before you start blazing into this kind of an issue, change of circumstances, you do want to find out if you're even going to be scratching the surface or not. More information, miscellaneous points. Domestic violence restraining orders carry a presumption that the parent who is the victim should have sole legal custody. I don't believe the presumption goes with physical custody, absent risk assessment issues, but sole legal custody. Now, first, let me say, as an aside, in my experience, all judges do whatever they can to avoid giving sole custody. It's very, very rare. Even in a case of domestic violence where the law says there's a presumption, I still see judges doing whatever they can to get over that. Many do it by just not giving a term. So you don't have to say shared physical custody, you don't say sole legal custody, then it doesn't matter. Because they just don't like it. The general belief now is that sole custody, absent a distinct specific need for it, sole custody doesn't help or benefit a child on average. So they do what they can to avoid it, but the restraining order can do that. It's important to know if you're in a restraining order on either side, you have to know that's going to impact your custody issues now and in your future. The erosion in 10 years I referenced in the beginning, it's still out there. Some are going to quote it. Some judges could possibly still even believe it's valid. I don't know if you're likely to hear a judge say yes or no to it. It's just safer to avoid using the term because of obviously appeal issues that will come with it, but it's still there, so you got to be ready for it. Parenting time is preferred over visitation, and you'll still see people using the term wrong, but it's an important distinction to know because it says something important about parenting and about the law, at least in New Jersey. We used to call it visitation, and now it's called parenting time because the courts finally realized that you're not visiting your own child. You're the parent. So when you have that child, you're supposed to make the decisions, which is why when we talked about day-to-day decisions, you decide what doctor they go to on your time. It may be a different doctor than the mother has on her time. You should be involving the parent in this discussion and choice, but when it comes to your time, because you're the parent, you make the decision. So that's why it was switched to parenting time. Alienation. Here's the term black versus black about college contribution, talked about reunification. I put this in here because people throw around this term alienation all the time, and obviously it's a very significant issue, but you need to understand not every case where a parent is trying to alienate or where you think they are trying, that you actually get alienation. Truthfully, in my experience, alienation requires, first of all, a great deal of time. You can't alienate a child from his or her parent that easily, especially if the other parent is involved, which is the other thing I think alienation needs, and that is cooperation of both parents. And I say cooperation kind of ironically, meaning the other parent needs to have been absent in some way. Now, any person listening to this on my Facebook or that feels they're a victim of alienation is probably going to be furious at me for saying that. But it's right. Because if you could be successfully alienated from your child, then you were either absent or you didn't take the proper legal steps early enough to negate it. I'm not saying good or bad, I'm just saying it's a matter of fact. So if you think alienation is occurring, you need to act promptly. You need to go into court, you need to file motions for enforcement, you need to document what's going on, you need to find experts to help you. You can't sit back, because if you sit back, then it may happen. This is a big issue with me because I'm often on the side of a client saying the mother's alienating me, and I'm the one that has to say she's not. It's not there yet, but if we continue this rule, we're going to be there. Determinations don't turn on money, nicer things, nicer neighborhood, as I mentioned earlier. You don't have to have 2 bedrooms. If you, again, we have a 3-pony rule. It just, the child only needs so much. I say this because a lot of people think these are going to be significant issues. They're not. They're important issues. All these issues are important. I covered like 20 of them. They're all important and in some degree almost equally important depending on the nature of the case and the children. But money is probably the lower level issues as opposed to cooperation, domestic violence, continuity of education. All those things are going to be much more important than who has more money and who has a nicer house. Alternatives when there's a great distance, and that in New Jersey can be Camden County from Essex County. More vacation time. We have generally a standard is 2 weeks non-consecutive in the summer. That could be 4 weeks, it could be 8 weeks. We have 3, maybe 4 extended school vacations. One parent maybe can have all of them because they don't get more equal, or they don't get a lot of weekends, but they don't have the 50% custody because it's too far. Our summer breaks, as I said. Advancements in technology courts utilize. Now, it's not really a good substitute for overnight time, at least not where we are right now. I know there's a lot of promise about AI and, having larger screens so you actually feel like you're there, but you don't feel like you're there no matter how large the screen is. So we use advancements for like FaceTime and more rapid, easy contact, but it helps, but it's certainly not a substitution. It's very important, or it's highly utilized in relocation, and you just can't physically be there. All right, next couple things to talk about. I always recommend avoiding the police station for pickup and drop off. A lot of people want this, one, because there might be domestic violence in the past. Other times, they're afraid there's going to be domestic violence. Sometimes they're just using it to try to suggest that the other person's a risk. I don't like it. Most judges don't like it. It sends a bad message to the child. It can actually even terrify the child that, oh, every time I'm going to see daddy, I have to have police around me. Now, I understand it's helpful in certain circumstances, and it may even be better for everybody involved. I usually recommend you consider like a firehouse first, because there you have obviously people around, you have a show of authority, but you don't have anything that's going to intimidate or traumatize a child. Matter of fact, children often like firemen or firehouses because they're cool. I would try that. A public place where there's a lot of people also is a good choice, because you're not likely to have a lot of domestic violence when there's a lot of people around. Another point is you want to understand and read a little bit about the Hague Convention. I'm not going to go into it here. That is the international convention that when the country is signed up for it, meaning they've agreed to participate in it, it works for an expedited way to resolve international kidnapping, for lack of better words, custody issues when one parent has fled a jurisdiction and refuses to return. Not every country is a party to the Hague Convention, so you want to find out if you have a parent who's traveling or from a foreign country, or might be going for whatever reason, and you have custody issues, serious custody issues. You want to make sure or find out if they apply or if they subscribe to the Hague Convention or not, so you know what steps you need to take. God forbid you have an international custody issue. Both parents, not just the one who earns more money, have a child support obligation, meaning if you have even equal physical custody, where you have 50% of the time and 50% of the time, there still may be child support. Again, because it's going to the needs of the child, not the income of the parents. Even under the Deffler case, if one party has if one party has more income than the other, even though they're sharing physical custody, there still may be a small child support component or child support payment made to the other parent. The reason is the court, or the theory, wants both houses to provide as equal of accommodations to the child as possible. And this isn't about having 1 or 2 bedrooms, but this is about a child having similar life. They don't want a child to be with mom who takes them on vacations and buys iPads and great stores, and then dad who can't afford to go to the movies. So if there's a larger income, there's going to be a shift or a child support payment to the lower income, not substantial, but enough that it provides the opportunity for the other parent to provide the same or similar kind of life that the child's going to have with the first parent. Shared parenting will reduce child support because there's an adjustment for every overnight that you have. As I was talking about earlier, where I have a client who has all day but not overnights. Any overnight, 12 hours or more, or circumstance that suggests will reduce. The more of a reduction, the more overnight you have, you may even get onto a different type of analysis, from a shared parenting to a sole parenting worksheet for child support, which is not like sole custody. It's just 2 different ways child support gets measured depending on how many overnights you have, which is 104, by the way. Just came up in there quickly for everybody watching. All right, so a couple other things. I'm going to just rattle through these quickly because I think I'm approaching my 60 minutes. I don't want to keep you guys any longer than I need to. And again, appreciate everybody here saying, oh, it's another client. I haven't seen her for a long time. Hope everything is well. For right of first refusal, which I think I touched on before, something I generally recommend. I think all custody arrangements should have it where feasible, and that is where one parent can't be with the child during their parenting time. The other parent should be given the choice of having the child. You usually want to have a time frame, meaning it's not just an hour that the person's running out to the supermarket. It doesn't mean they have to turn the child over, and it doesn't have to mean overnight either. But if for instance, the minimum amount of time I usually recommend is like 5 hours. If a parent's going to be away for 5 hours, they should provide the other parent at least the opportunity of having the child. Even 3 hours, if you live close to one another, is something that should be considered. You can do 1 hour. I'm not saying that you can't. It may be a lot of running back and forth. I guess the best way to put it is the lower amount of time, the more cooperation needs to exist in the relationship for it to work. So use that as your bright line. Availability of extended families to assist. This is important. This goes to fighting for sole custody, or not, I'm sorry, not sole custody, the shared physical custody, equal physical custody. The resources that you have available are going to be very significant, especially as a child ages, because having extended family to influence children is very important. So that will weigh in a court's favor sometimes if you have maybe grandparents around to influence a child as he or she grows up, as opposed to putting them into a daycare where they're going to be taking naps on the afternoon. Child support's not taxable. Just so if you think that you're going to get a tax break by paying it, or if you think the other person's getting this great break by having it, it's not the case. By the way, alimony isn't either any longer. As of this year, that changes. Not for those paying alimony, but those that are going to be paying alimony, those under prenuptial agreements also, just as a side point so you know that. Unmarried fathers, told you I touched on a little bit, unique issues that may be in cases where there. So when you're unmarried, you're still going to be presumed to be the father. Now, if a child's born in a married couple, the child is presumed to be that child. But that doesn't mean, let me say it differently. There's a presumption when you're married and a child is born that you're the child of, or you're the father of that child. If you're unmarried and a child is born and your name's on the birth certificate, you're also going to be presumed, but you do have the right to seek a paternity test. Not necessarily the same in a divorce case. I'm not going to go into that because it's more relevant to divorce. If you have an issue or a question about that, just email me and we'll discuss it. You can sign a certificate of parentage and consent to being the parent. As much as I want to encourage people to be responsible and reduce litigation, I don't necessarily recommend signing that without a paternity test. I think a paternity test is better for everybody involved because it eliminates the question. You may get a lot of flack from it, especially when you come out to be the parent, but you don't want to wait 10 years and find out that you're not the parent because it's too late then. It eliminates the question by having it done available. It has to usually be by order of the court. I don't know if there are other organizations that will do the testing absent an order. The only ones I know, like LabCorp, for instance, require a court order for it. So I'm not really sure. I've never seen any or heard of any that allow for it. So if you know anybody who does, I'd actually appreciate if you would send me the information. Relocation. I told you I'd touch on relocation. And one of the biggest, most difficult contested issues, you're going to hear a lot about a case, Bisbing versus Bisbing. Came down, I think, from the Supreme Court just recently, where they said that a best interest analysis must be utilized to determine cost relocation. This case, to most others than myself, has been a significant upheaval of the law. I actually represented the father in this case at the trial court level, and I'm free to say this now because the appeal is over, got one of the worst decisions I've ever seen by a judge. As much as I respected the judge, had no idea the law or the procedure and bumbled it so badly that it went to the Supreme Court and it came back. The reason I'm pointing this out is that a lot of people think that Bisbing changed the standard for relocation. I don't think it did significantly because if you know the facts of that case and the agreement they had for custody was unique to any case I've ever seen and probably unique to cases going forward. What I do recommend you use this case for is if you can get a copy of the property settlement agreement, because I'm not sure if I'm allowed to disperse it to anybody else, but if you look at the terms they used in there and how the judge erroneously interpreted it, you might want to use those terms in your own agreement or even improve upon those terms because we now see how it played out. But they had a very unique, fact-specific custody arrangement that spoke to relocation in a way that I've never seen other cases before, but I'm sure we will now. Bowers versus Lewis is what used to be before Bisbing the standard for relocation. It's now considered flaw. It used to say that what was good for the custodial parent was good for the child, in a nutshell. So, and like I said earlier, mom says, I want to go to Florida because it's sunny, I can get a better job, and my parents are there to give me babysitters. That inures to the child's benefit, but it's not best for the child necessarily, it's best for the mother. Well, under Bowers versus Lewis, that would work, and that's what people were doing for decades until we got Bisbing. Important tip is assert your right for primary custody in the beginning of your case. And I don't know if I have this in here, but you also want to assert relocation if you're getting divorced. Partly when it comes to primary custody, you want to alert the court to that in the beginning because you want to show that you're coming from a good faith position. Once you get into heated litigation and you say all of a sudden I want primary custody or I want equal custody, it may look retaliatory as opposed to the best interest of your child. When it comes to relocation, it's even more important, and this was partly the issue in Bisbing. Relocation, if you, under the current case law, seek to relocate 1 year after your divorce, within 1 year, I think it is after your divorce agreement is entered, it's considered a bad faith application because the court will presume that when you negotiated throughout your divorce, which can usually take a year or so, throughout your divorce, you negotiated and relied upon the custody arrangements you were agreeing to, and then next you file and say, I'm going to move, it's presumed that you had some idea that you were going to move and that you led the other parent into a custody arrangement, which may have given them less time so that you could have an easier relocation application. For instance, if you negotiate in your divorce and you're the parent of primary residence and you have 5 out of 7 days and dad has alternating weekends, and then you turn and say, well, I'm the parent of primary residence, the child's living with me, and I want to move to Florida, it's bad faith because dad might not have agreed to that situation had he known you were going to be moving and using it as a basis for relocation. So don't do it. I may have, wait. Okay, here's a tip that everybody's going to balk at. Develop an amicable relationship with the mother, I say mother because this is for fathers, and promote co-parenting. As difficult as it may be, I have so many cases where the parents just can't get along. They just can't get along, and what happens is it influences the child's health significantly. And a lot of people can't see it. They can't see that it's their strife that's causing that. And it's everything from anxiety to constipation that little kids are experiencing now, unlike any I've ever seen. If the issue is your child, you always want to work to the child's best interest. Trying to cooperate is the most important. Goes back to the very first factor that I said is going to be the most important. The ability of parents to cooperate and communicate. You have to do your best, and you really have to try to do your best. And when you can't, and when it's not working, is when you're able to come to the court and say that we can't communicate, and custody has to be changed because of it. Avoid using old school attorneys who think child is best with his or her mother. And I say this not to insult other attorneys, and there still are many. It's just archaic and it's unfair. It's almost unconstitutional. I actually think it is unconstitutional. It just hasn't got to that stage yet. There's no way to have a bright line rule that says every child is best with any person. But this exists, and you're going to see it. I just saw it with a court-appointed expert who said children need stability and it should be with their mother. That's absurd. But lawyers will have that opinion, judges will have the opinion, and you have to be ready to say that's absurd and show that the sciences, the social sciences don't suggest it, the statute doesn't suggest it, and the current progression of the law doesn't suggest it. All right, so that is it. I see another good friend of mine. Hello back to you. Thanks for showing up, supporting me. To those watching, I hope this helped. I'm going to check real quick on my control panel on the webinar, see if there are any questions. I don't see any questions. I don't see anything on my Facebook, although I'm not really sure how they would actually show up on the Facebook. So I think with that, I'm going to be signing off. If you do have any questions that you didn't get answered, you can email me at brad@micklinlawgroup.com. That's MICKLIN, lawgroup.com. It should be on your screen. To those on social media or the webinar, I'm throwing it up again so you can see it. People on Facebook can just send me a message. With that, I'm going to wish you all a good night, and I will see you, I think I'm on tomorrow at 2 o'clock. So that would be the 1st. Good night.